Good afternoon, everyone. My name is Bill Pokorny. Thank you for joining us on today's webcast, summarizing the new paid sick leave and FMLA leave requirements in the Families First Coronavirus Response Act that was signed into law yesterday by President Trump. For those of you who aren't familiar with our firm, Franczek is a boutique law firm located in Chicago focusing on labor, employment, and education law. We serve public and private employers of all sizes, as well as K-12 and higher education institutions. I'm joined today by my partner, Tracey Truesdale. Tracey and I serve as co-chairs of our firm's labor and employment practice group, and I'm also the co-chair of our higher education practice. Tracey and I have both devoted the better part of our careers to helping employers work through difficult issues involving employees and labor relations issues. I can honestly say that nothing I've done in my career up to this point has held a candle to our experience over the last week, or to what I know that we and all of you listening are going to be dealing with over the coming months. I know that we're both very glad to be able to be here today to help you shed some light on at least part of the recent developments and going forward to figure out how to guide your organizations through these extremely challenging times. During today's webinar, you'll have the ability to type and submit questions in the chat function near the bottom of your screen. We've already received many questions, both in the registration forms and from folks who have already logged on to the webinar today. We'll do our best to answer the most common questions and to address others through the communications that we'll continue to issue after the webinar through our mailing list. But if you need immediate assistance, as always, please don't hesitate to reach out to me, to Tracey, or to any of the attorneys here at Franczek, and we'll be very happy to try to get you the answers that you need for your organization. Everyone attending today's webinar will receive a copy of the webinar recording or a link to the recording, this presentation, and a survey later this afternoon by email, so watch your email box. With that, let's jump into the substance of our conversation today. Again, the subject of this webinar is the Families First Coronavirus Response Act that was signed into law last night by President Donald Trump. Just to give everybody an overview of the history of this legislation, very brief history, it was introduced into the House of Representatives last week on March 11th. It passed the House early the morning of March 14th. There were some technical corrections made to the House legislation on March 17th that actually included some fairly significant substantive revisions to the legislation that the House initially passed. So if you looked at or read summaries of the legislation before those technical corrections were made to the legislation, there have been some significant substantive changes that you should be aware of. The legislation was passed by the Senate yesterday, March 18th, without any changes from the House version of the legislation, and it was signed by President Trump on March 18th. And the slide says becomes law. It is law, but it takes effect on, or at least the leave provisions that we're talking about today will take effect on April 2nd, 15 days from the date that they were signed. All right, so let's talk about the substantive provisions of the Act. And first of all, I'm going to turn it over to Tracey to talk about the first major provision, the Emergency Paid Sick Leave Act.
Thanks, Bill. Good afternoon, everybody. We're going to talk about the Emergency Paid Sick Leave Act first. And it's important to note that for purposes of all of you participating on the call, this is going to apply to virtually all of your employees. It's going to apply to, as Bill said, it's effective 15 days after the enactment, which is April 2nd. And it is going to apply to all public sector employers, as well as all private sector employers with 500 or fewer employees. So there's no threshold headcount for public sector employers, but there is for private sector. The leave will provide up to 80 hours of paid sick leave for individuals affected by COVID-19. And we'll talk about there's 6 circumstances that are covered by the Emergency Sick Leave Act. And there's the slide with the covered employers. There is potentially a small employer exception. The Secretary of Labor has the authority to adopt regulations to exempt small employers of 50 or fewer employees if from the requirements of the statute, if the requirements would jeopardize the viability of the business as a going concern. Now, we don't know exactly how that's going to operate. What we expect is that the Secretary will adopt some sort of a process by which employers would qualify for the exemption, and whether that's sending in, an application to be exempted, we're just not quite sure at this point, because the Secretary of Labor has not issued anything in the way of regulations or guidance yet on this statute. There's a slide here on joint employment. We had a couple of questions come up prior to the webinar about what happens in terms of coverage if you have a subsidiary-parent relationship and the subsidiary would not ordinarily, it would not hit the threshold of 500 employees. They would be below that, but if accumulated with the parent company, the headcount does exceed 500 employees to take the employer outside of the purview of the Act. In that circumstance, we're not entirely clear what the Department of Labor will do, but what we expect is that the analysis will be very similar to what is currently used under the Fair Labor Standards Act, looking at the amount of control that parent corporation has on the actions of the subsidiary. Who is responsible for things like hiring and firing, who's in charge of supervision, who controls the work schedules and working conditions to a substantial degree, who determines the rate and method of paying employees, and who maintains personnel records. If those functions are blended or are maintained by the parent, we think employers will have a strong argument that they do accumulate with the subsidiary and you would exceed the 500 employee threshold in that circumstance. So the qualifying reasons for leave. The employee is unable to work or is unable to telework for certain reasons. And that's an important addition that was made on Monday evening when the Senate sent the bill back to the House of Representatives for further what they call technical corrections. But this was a pretty significant correction because that verbiage, unable to work or unable to telework, was not in the original bill when it passed the House over the weekend. That was added in sort of the negotiations between the House and the Senate on Monday evening. So assuming your employee is unable to work either physically in the office or by teleworking, they can take leave for the following circumstances. Because they're subject to a federal, state, or local quarantine or isolation order related to COVID-19. And I'm talking to you from Oak Park, where we are about to enter into a shelter-in-place order issued by the Department of Public Health. So arguably that would fit circumstance number one. Number two, the employee has been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. That could be an individual who has a family member. We're seeing a lot of college students come home who potentially have been exposed. That family member has been told to self-quarantine because of a family member or because the employee, him or herself, has had exposure. Number three, the employee is experiencing symptoms of COVID-19 and is seeking a medical diagnosis. They would qualify. The employee is caring for an individual who is subject to an order, either a quarantine order or has been advised by a healthcare provider to self-isolate or quarantine. And that, again, there's a significant change in that particular circumstance. That particular circumstance initially read that it was to care for a family member, and the House of Representatives went back and revised that language, and now it's caring for any individual. So the person that they're caring for does not necessarily have to be a relative. The fifth circumstance is when the employee is caring for a son or a daughter if the child's school or daycare or child care facility is closed or otherwise unavailable. A number of us, are working under those circumstances right now with, millions of children across the United States being, forced home because of school closure. So that's going to apply to an awful lot of folks, although, again, you have to bear in mind be unable to work or to telework gloss on all of this. And then number 6 is the employee is experiencing any other substantially similar conditions specified by the Secretary of Health and Human Services in consultation with the Secretary of the Treasury and the Secretary of Labor. So that's sort of a catch-all that allows those parts of the cabinet to extend the basis for leave. There is an exception within the Paid Sick Leave Act, and Bill will talk about this for Family and Medical Leave Act as well. When your employee is a healthcare provider or a first responder, you as the employer may elect to exclude them from this paid sick leave requirement. Those two positions can, as I said, be designated affirmatively by you as the employer, and there is also provision in the statute to allow the Secretary of Labor to designate those particular positions as exempt from the sick leave entitlement. What's noticeable about the statute is it does not define either the term healthcare provider or emergency responder, but presumably that is going to be, for healthcare providers, it's going to be nurses, doctors, and for emergency responders, your fire, police, and EMTs. The amount of leave for full-time employees is going to be 80 hours. What to do if your employees are considered full-time and are working less than a 40-hour week or are paid for less than a 40-hour week. We are not quite sure what's going to happen in that circumstance, but what we expect may happen is something similar to what happened under Chicago and Cook County paid sick leave, where if you deem them to be full-time, they are presumptively working 40 hours, and this full-time entitlement of 80 hours of paid sick leave will effectively be 2 weeks for those individuals. For part-timers, the calculation of their leave entitlement is a little stickier. We're looking at the number of hours that the employee works on average over a 2-week period. Now, the legislation does not define what 2-week period you are supposed to use to make that calculation. Hopefully that will be addressed in the Secretary of Labor's regulations, although I think we can anticipate you're going to have to use 2 weeks where the employee had a fairly normalized part-time schedule to make those projections. What to do when your employees have a variable work schedule. The legislation provides a number of different ways to compute the employee's leave entitlement in that situation. If you can, you're going to use an average of their scheduled hours over their prior 6 months, including any leave that they would have taken. So that leave period, however you treated it, whether you treated it as full-time or part-time, that would factor into your calculation of what's an average amount of hours worked over the prior 6 months. For your newer employees who do not have 6 months of employment history, what the statute says is that you would use the reasonable expectation of that employee at the time of their hire with respect to what their work schedule would be. So there's going to be a little bit of wiggle room there and a little bit of ambiguity as to what the anticipated work schedule might have been if there's someone who's, let's say, seasonal or part-time, but you may have a little bit better degree of predictability if you have an offer letter or something like that to go by. Go back here. How are we paying these individuals? Well, the rate of pay for an employee themselves who is sick or has been directed to isolate, you're going to pay them the greater of their regular rate under the Fair Labor Standards Act, which is calculated based on their hourly rate of pay plus any non-discretionary bonus. Does not include things like overtime or discretionary bonuses. Their FLSA minimum wage, which currently the federal minimum wage is $7.25 an hour, or their state or local minimum wage. And in the state of Illinois, the current minimum wage is $9.25 an hour, and in the city of Chicago, it's $13 an hour. So you look at which is the greatest of those. For most of your employees, that's probably going to be their regular rate of pay, what you're paying them. But for folks who may being paid less than the minimum wage, like tipped employees, you may be bringing their compensation up for purposes of this sick leave entitlement. And again, you're using that rate of pay for purposes of their own illness or requirement to isolate. Now, if they are caring for a child or another individual, so that other individual or the child is sick or has been isolated because of COVID-19, or the child's school or daycare has been closed, you're going to pay them 2/3 of the rate that we just talked about from the prior slide. So it's a reduced benefit when it's the need to care for someone else. And here's a slide on regular rate. It's the total of non-overtime pay. It's your base pay, non-discretionary bonus, shift premium, incentive comp, et cetera, divided by their total hours worked for the week. So the maximum benefit. This was a key addition that was made to the legislation on Monday evening when the bill was sent back by the Senate to the House of Representatives. Previously, there had been no cap. Right now, if you implement a written sick leave policy, you can cap employee benefits when they are taking leave for their own illness or isolation at $511 per day, or an aggregate of $5,110, which is the equivalent of 10 days of sick time. If they are caring for a child or someone else, you can cap their benefit at $200 per day, or $2,000 in the aggregate. And again, that represents the 80 hours or the 10 days of paid sick leave. So those caps were not in the original legislation that passed over the week, or that passed the House over the weekend, and that was a significant change requested by the Senate. How does this interact with other forms of leave that you already have on the books? This is a question that we received in a number of registrations, as well as even on the bottom of the screen here. This emergency paid sick leave is in addition to any other leave you are already providing. And that includes any leave that you may have adopted over the past couple of weeks in response to COVID-19. And I know there are employers out there who have done that, who have issued leave policies to meet the needs of employees who are impacted by the crisis. So this is going to be in addition to what you already have, and the statute is clear on that. It is at the employee's option to use the emergency paid sick leave before other leave that they may have available. You cannot compel the order of the leaves, and you cannot charge, unlike FMLA, where we were used to running things concurrently. We're used to taking that period of unpaid leave and running any paid time against it. The time that employees are receiving for emergency paid sick leave cannot be charged against any existing bank they may have for PTO or vacation or employer-provided sick leave. So this is in addition to anything else you may already have. Emergency paid sick leave is available from day one. I think that's how I started the presentation. This is really available to everyone. If you are a covered employer, it's going to apply to virtually all of your employees, save, if you're a healthcare provider or emergency responder. There is no, a period of service or requirement to become eligible. The good news is, like many other forms of sick leave, this is not payable upon termination. This is designed to get employees through the crisis that we are facing and give them paid time, given the loss of income that could be occasioned by being isolated or affected by this virus. It is designed to sunset on December 31st, 2020, when hopefully sort of the peak of this crisis will have passed. Whether it would be extended at some future date, we don't know. But right now, that's how the legislation is written, is to expire on December 31st. And corresponding with that, there is no ability to carry over paid sick leave under this emergency statute into 2021. Now, just to be clear, the statute includes, just like most employment statutes, including the FMLA, provisions, protecting employees from discrimination or retaliation for taking leave under the statute. And one of the key things that Congress included was that employers may not require employees to take leave to find a replacement for shifts. We wouldn't be doing that under other forms of statutory leave either, but that's something that Congress made clear in the statute. How does the employee give you notice that they need to take this emergency paid sick leave? Well, the first day of absence is sort of a free no call, no show day. They do not have to call in their absence, although they certainly can do that, but that's not something that's required for them to receive the benefit under the statute. As their need for leave progresses, if they need days 2 through 10 of leave, they can be required to comply with reasonable notice procedures. Presumably, that's going to be something that's in line with your existing attendance and reporting requirements. Provided that those are reasonable, you can require an employee who's availing themselves of this emergency paid sick leave to follow those in order to receive the benefit. A key provision that seems to be missing from this statute is any provision as to how employers are going to be able to assess the legitimacy of an employee's request for leave under emergency paid sick leave. There is no certification requirement right now, no documentation requirement. Certainly certification and documentation will be problematic in the coming weeks if we are talking about certifications from someone's physician. But you still think that there will be some mechanism for employees to either self-certify or to provide proof that their child's school is closed, for instance, or an isolation order, something to their employer to back up the need for time off under this emergency statute. In terms of what notice you as an employer will have to give, the Department of Labor is supposed to publish a poster within the next 7 days. I checked their website an hour ago. That poster is not available as yet. There's no guidance really, except the guidance that existed prior to this congressional action, which is fairly boilerplate material about how to compensate employees in a pandemic. Once that poster is made available, you'll need to post it in the workplace. If your employees are working remotely, we're certainly encouraging you to send it electronically, making sure that employees have notification of their rights under this new statute. And I think that's going to be sort of the way, it is going to be communicated because we have so many employees working remotely. Multi-employer plans and sick leave policies. There is a carve-out. If you are contributing to a multi-employer fund that provides sick leave benefits, employees can draw on that fund to receive their benefit, and you do not have to provide anything in addition, so long as you are providing the equivalent of the statutory requirement, the 80 hours, or some fraction of that if they are part-time. So you can rely, that is a circumstance where an employer is able to draw on an existing bank of sick leave, but it is a very narrow exception. And an employer who who is bound by these new sick leave requirements is still going to be bound by its existing collective bargaining obligations. This does not relieve you of any negotiated sick leave obligation. And I think that takes us to emergency FMLA, which Bill will talk about.
All right. And just a brief word on enforcement before we talk about the FMLA provisions. So the sick leave provisions are going to be enforced. If there's a violation, they'll be enforced as a violation of the Fair Labor Standards Act. So if you fail to provide required sick leave to an employee, effectively you will be denying them minimum wage, and it'll be treated as a minimum wage violation. Likewise, if there's an employer who fails to, continue to employ or fires an employee who's used the paid sick leave under the Act, that would be dealt with similarly to an FLSA retaliation lawsuit. The same sorts of remedies would be available there. All right, so let's talk about the family and medical leave provisions of this new law, the Emergency Family and Medical Leave Expansion Act. So first, just to hit the highlights of the new law, again, like the sick leave provisions, taking effect on April 2nd, 2020. So for example, here in Illinois, we know that at least presently schools are closed through March 30th. This does not apply to whatever happens between now and April 1st, 2020. So we're really talking about absences that are occurring after April 2nd. The new FMLA Expansion Act expands the reasons for FMLA leave to include a new qualifying reason, specifically qualifying need related to a public health emergency. And leave taken for this reason, unlike regular FMLA leave, is at least partially paid leave. So that's an important change from the current FMLA. So who's covered by this new provision? Under the current regular FMLA provisions, those cover private employers that have at least 50 employees and basically all government employers. These new provisions also cover government employers, the same government employers that are covered by the FMLA, but they also add private employers with fewer than 500 employees. So basically the same group of employers that, as Tracey discussed, are covered by the paid sick leave provisions. The new FMLA Expansion Act also expands the universe of covered employees. So currently, to be an eligible employee under the Family and Medical Leave Act, an employee has to be employed for at least 12 months. They have to have worked at least 1,250 hours during the 12 months preceding the start of their FMLA leave. And they have to be employed at a work site with at least 50 employees within a 75-mile radius. The new provision greatly expands the universe of covered employees to include essentially every employee who's been employed for at least 30 calendar days. So this is a difference between this law and the paid sick leave provisions, in that there is at least a minimal length of employment requirement, but instead of 12 months, it's now basically 1 month under this new law. Like the paid sick leave requirements, there are some exemptions. First of all, there is an exemption for healthcare providers and first responders built into the statute. And also, like the sick leave provision, there is an exemption that allows the Secretary of Labor to, by regulations, exempt small businesses with fewer than 50 employees if complying with the requirements of the law would jeopardize the viability of the business as a going concern. So again, we don't know exactly how the process of applying for or availing yourself of that exemption will work. If there has to be some form that's filed with the Department of Labor or we don't think there will be a hearing process given the number of these that we expect to be filed, but right now we really don't know what that process will look like. So we have to wait for guidance from the Secretary of Labor on that. We have a similar joint employer issue here in terms of determining which employers are going to be covered. If you have a large organization with multiple separate operating subsidiaries, do we look at a subsidiary on its own? And if a subsidiary has fewer than 500 employees, is that covered? Again, we need guidance from the Department of Labor here, but based on our read of the statute, it seems likely that this will be governed by the Family and Medical Leave Act's existing rules for joint employment and for counting how many employees an organization has for coverage purposes. And like the rules under the Fair Labor Standards Act, these rules really focus on control factors. So how much control does the parent entity exercise over HR issues at the subsidiary entities? This is a highly fact-specific inquiry, so if you have concerns or questions like this, we do strongly recommend that you talk to your employment counsel and figure out how these provisions may apply to your workplace so that you know whether or not you are covered. All right, so what is a qualifying need related to a public health emergency? When the House originally passed this legislation back, in the good old days on Saturday, the legislation was actually far broader in terms of FMLA leave than was included in the version that the president signed yesterday. There were a number of different provisions that allowed employees to take FMLA leave with pay for their own health conditions or to care for a family member who was incapacitated had to stay home for COVID-19 related reasons. Those provisions were stripped out of the final bill. So what we have left is only this provision that says an employee can now use FMLA leave if they are unable to work or telework due to a need for leave to care for their son or daughter under 18 years of age of such employee if the school or place of care has been closed or if the child care provider of such son or daughter is unavailable due to a public health emergency. Quite a mouthful, but essentially if somebody's kid's school or daycare center or usual daycare provider is not able to care for their children and the kids are home because those facilities are closed, the employee is eligible for leave under this provision if they meet all the eligibility requirements. How much leave are they eligible for to take care for those kids who are home from school or daycare? It's up to 12 weeks. But note that one thing that this law does not do is expand the total bucket of FMLA leave that is available to employees. All it does is add an additional reason that employees can use toward their FMLA. So if an employee has already taken 6 weeks of FMLA leave in their current FMLA 12-month period for, say, a knee surgery, and now they need to be home to care for a son or daughter who is off of school, they have 6 weeks of FMLA leave remaining. And likewise, if an employee has already exhausted all of their FMLA leave, they aren't entitled to any additional FMLA leave under this provision. They would, however, be entitled to 2 additional weeks under the paid sick leave provisions that Tracey discussed. So there is some additional leave entitlement there over and above what employees would be entitled to under regular FMLA. All right, now as I mentioned, this FMLA is partially paid. So ordinarily, the rule is that FMLA is unpaid leave. An employee who has other paid leave available to them, like sick leave or vacation or PTO days, can elect to apply those days to their FMLA leave ordinarily, and that paid leave then runs concurrently with the employee's leave under the Family and Medical Leave Act so that they can receive partial pay for that time. That rule still applies to this new leave, but there's some additional provisions. So the first 10 days of leave under this Emergency Family and Medical Leave Expansion Act is treated like existing FMLA. The difference is that employees now have this additional 2-week bucket of emergency sick leave that they can apply to that first 10 days. So even if they don't otherwise have leave under a covered employer's policies, they now have this paid sick leave provision. An employee may elect to substitute their paid leave for this first 10 days of unpaid leave, but an employer cannot require an employee to substitute their leave for that time. So if an employee says, look, I want to preserve my available paid leave, either existing sick, PTO, vacation leave under the employer's policies, or this emergency paid sick leave under the new law, I want to save that in case I need it later, the employee can do that and take 10 days off unpaid. After those 10 days, under this new Family and Medical Leave Expansion Act, the employee is paid at 2/3 of their regular rate of pay times the number of hours the employee would otherwise work. So how's that calculated? We use the number of hours. Again, the employee would ordinarily be scheduled to work during the week that they're taking that leave. And like with the paid sick leave provisions that Tracey discussed, if the employee's schedule is variable and unpredictable so that you don't know in advance how many hours an employee might work, you have to use the employee's 6-month average, or if an employee hasn't been around for 6 months, you use the reasonable expectation of the employee at the time of hiring, which again may differ from their actual average of hours work, but that's the language in the statute. The maximum paid benefit for FMLA under this provision is similar to the paid benefit for taking care of a child or a family member at home under the paid sick leave provisions, and that's $200 a day. So again, it's the 2/3 of the employee's regular rate or the minimum wage if their regular rate is below the minimum wage because they're a tipped employee, up to a maximum of $200 per day. And the total aggregate benefit payable under this provision is $10,000. So those are the caps that employers might be subject to, and this is per employee. Like the paid sick leave provisions, this emergency FMLA expansion provision sunsets on December 31, and there is no carryover of unused FMLA into any following years. Like the sick leave provisions, there are provisions against discrimination or retaliation against employees who avail themselves of their rights under this new law. And again, employers can't require employees who take leave to find a replacement for any of their shifts. What do employees need to do to avail themselves of leave under this provision? The law says that when the need for leave under the Act is foreseeable, the employee must provide as much notice as practicable. So generally speaking, as schools are closing, and that's really the only thing that we're talking about here, school and daycare closures. When schools are closing or daycares are closing, employers or employees are receiving at least some advance notice of this so they know not to send their kids to school. So under the Act, employees should be able to provide notice of that. Generally, I mean, at least here in Illinois, for people enrolled in public school, this is happening at a state level, so employers should know when schools are closing or when they're scheduled to remain closed. They're currently closed. But it is incumbent on employees to report to their employer, not just that, hey, I have a kid and school's closing, but that I believe that I'm not able to work during this time period and I'm going to need to avail myself of leave. Again, this is another area where there may be additional guidance from the Secretary of Labor, from the Department of Labor, as to exactly what that notice needs to look like and what employers can expect and require of employees under this situation. Like with the sick leave provisions, there is currently no reference in the legislation to certification or documentation. Although in this case, again, because it's based on school closures primarily for most employees or daycare closures, it's a little bit less of a certification issue than somebody simply saying that I'm sick and I need to take time off. Like with the sick leave provisions, and presumably this will be part of the same publication from the Department of Labor, there will be a poster that employers are required to post in their workplace. And again, we'll see what the regulations say, but it's expected, and it's probably a good idea, whether it's required or not, that employers may need to send this publication out to employees who are working remotely and who aren't currently in the workplace. As with the regular FMLA, when employees use leave under this FMLA Expansion Act, they're entitled to reinstatement to the same or equivalent position with respect to pay, benefits, and terms and conditions of employment when they're ready to return from leave. Now, the new law does add an additional exception for small employers. It says that employers with fewer than 25 employees don't have to reinstate an employee whose position is eliminated for reasons related to the public health emergency, which can include economic circumstances of the business, if the employer has made reasonable efforts to reinstate the employee to the same or an equivalent position, and the employer makes a reasonable effort to contact the displaced employee about an equivalent position if one becomes available within a period of 1 year. Now, what's interesting about that is even under the regular FMLA provisions, an employer that eliminates a position due to an economic downsizing, for example, isn't required to reinstate the employee to a position that no longer exists for reasons that are independent of the fact that the employee has taken FMLA leave. So it's not clear if the DOL or if Congress is saying that that exemption is somehow narrower than it's previously been interpreted, or if possibly the idea is that, look, a small employer may be more directly affected by the absence of one or a handful of employees who are absent from work, and that employee's absence may well contribute more directly to the need for a position or elimination, or even the business closing or closing down part of its business. So again, we'll need to look for guidance from the Secretary of Labor as to exactly what this provision means or how it will be applied. It's unclear as it currently exists. In terms of enforcement, again, this is part of the Family and Medical Leave Act, so the enforcement provisions of the FMLA will apply. One interesting provision of the legislation is a provision that says certainly employees can file suit under the Family and Medical Leave Act, but the legislation says that for employers with fewer than 50 employees, it appears that there may be no ability to file a private lawsuit. Now, the Department of Labor appears to still have authority to enforce the statute. So small employers under 50 can't just ignore the law at their leisure. They may still be subject to Department of Labor enforcement actions. But at the very least, as the law is drafted, it appears that there's not a private lawsuit that can be filed against them. Now, lastly, before we start to turn to some of the questions that I know have been rolling in and that were rolling in before we even started the webinar, we do want to touch on the tax credits that are provided under this new legislation to help minimize the economic burden that this clearly puts on a large number of employers in the country. So the tax credit provision of this legislation says that, look, in order to pay for the cost of this, the federal government is going to allow private employers to take a credit against the employer's share of Social Security taxes in 100% for 100% of all of the emergency sick and FMLA leave paid up to the cap amounts that are provided in the statute. And they can also take a credit for the cost of premiums for group health plan expenses due to the expanded leave under these provisions. So that's a significant amount of financial help for employers. And even beyond that, if the amount of the credit exceeds the employer's total tax liability for the employer share of Social Security tax, that's treated as an overpayment and can be refunded to the employer. Now, there are a lot of questions as to exactly when those refunds may be available and how quickly employers can gain access to these funds. And I will be the first to point out that I am not a tax lawyer, and so some of those questions may need to be deferred to tax advisors. But at the very least, this provision does hopefully take some of the sting out of these provisions for at least private sector employers. Public sector employers, however, do not, at least under this provision, at least under this law, get any help from the federal government to pay for these benefits. These tax credits are not available to government employers. So that could be a major factor that government employers need to take into account as they plan how to deal with this crisis. All right. So a few to-do items before we turn to some of the great questions that you've been asking. Number one, if you think that there's any chance that you may be covered by these provisions, determine if you are going to be covered. And if you have any questions about that, talk with your employment counsel. Watch for that Department of Labor guidance to come out. There will be new information on what these requirements are and what employers are supposed to be doing in response to this law. So watch for that information, and we'll continue to post it as it becomes available to us. When the Department of Labor notice becomes available, make sure you get that information out to your employees as required by the deadline. And perhaps most importantly, if you are covered, you're going to need to factor this leave into your contingency planning. It's going to affect not only your out-of-pocket spend for your costs for payroll, but how you're able to cover your operations for the duration of this crisis. Work with your employment council to develop policies, procedures, employee communications to make sure that your employees know what benefits are available and what you expect of them when they're using these benefits. And lastly, make sure that if you're a private sector employer, talk to your tax advisors regarding the tax credit options and how you can maximize the availability of those credits to help your organization weather this storm. All right, so with that, let's turn to some of the questions we've been getting. And Tracey, I don't know if you've been monitoring the questions as they've been rolling in. Are there any you want to start with?
Yeah, there is sort of a common theme that's coming through about, well, what happens if at the time that your employees, at the time this becomes effective, and you have employees who have already been put off of work for lack of work, they've been laid off, they've been furloughed, can they avail themselves of this paid sick leave? I think the answer to that is no in that circumstance, because they are not unable to work or to telework because of one of the 6 enumerated conditions in the emergency sick leave part of the statute, nor would they be idled because of a school closure or a daycare closure, under the emergency FMLA portions of the statute. They're idled because there isn't enough work to do, presumably because of this crisis. So I don't think the benefit is available to them under those circumstances. Bill, I don't know what your thoughts are.
Yeah, I think that's exactly right, Tracey. And the other things that I'd suggest that employers look at, and we've been talking a lot with employers about as we've figured out how to deal with these situations, if you are shutting down operations either in whole or in part, or certain employees, there is likely going to be some eligibility for unemployment benefits, and the state has been working to expand the availability of those benefits. All the states, I think, at this point have been working to expand the availability of those benefits. I know here in Illinois, the governor has waived the 7-day waiting period for unemployment benefits. So that's something that you'll want to consider, and also you'll need to communicate with employees about their eligibility for benefits. It's one of the requirements under the Unemployment Act. In addition to that, you'll need to think about, if there's a possibility that you're letting people go, even if you hope to be able to bring them back at some point, there's a possibility that you may not be able to bring them back. You may need to think about whether you need to issue WARN notices. So those are notices that have to go out in the event of plant closings or mass layoffs of certain numbers of employees. So if you're not familiar with the requirements of either the federal WARN Act or the WARN Act in your state, make sure that you understand what those requirements are.
Yeah, and with respect to WARN in Illinois, so we don't have a number of folks panicking because they've been putting people on layoff or furlough. You have to anticipate that the employment loss is going to be 6 months or greater. So if you think you're going to be able to bring them back in 30 days or 2 months, you're likely not going to have triggered WARN by what you've done so far. But as we just don't know how long this pandemic will go on. WARN may be something that employers are going to have to start complying with. But I don't want folks to panic on this call because we're not quite there, I don't think, yet for most employers.
Yeah, that's right. Thank you for clarifying, Tracey. So, again, if you haven't looked at the requirements of the law, make sure you're talking it through. But, for most employers that plan to bring people back, that's right.
Right.
One question that's come up, and I want to make clear, was whether these laws apply to higher education institutions. And apparently there's been some confusion on that front. There is nothing in these laws that singles out higher education institutions as exempt. So an institution that otherwise meets either the employee count, a private institution, so falls under 500 employees, so for those smaller colleges out there, or is a public agency that's subject to the FLSA and the FMLA, those institutions will be covered by these provisions. I think that's right. Tracey, anything else there for higher ed?
No, I think that's right. Something else, there's a related question, quite frankly, and it is a higher ed question, but for universities, there's a question that have their own medical or police departments within the university system. Could they be exempted while other employees at the university are not? And I think that's 100% right. I think you can exempt those employees as first responders and healthcare providers. We'll know more if the Secretary of Labor gives us a more definitive read on how the Department of Labor is interpreting those two categories. But I think sort of common understanding would cover, the university police departments and certainly your medical personnel.
Yeah, I think that's absolutely right. We had a question about for small public sector employers with 50 or fewer employees, are any of the exemptions for small employers under 50 people likely to apply to those entities? That's a good question, and I don't know the answer right now. I think the issue is that the exemptions apply if complying with the requirements of the Act jeopardize the business as a going concern. So for a public sector entity, I think it's hard to say that, the complying with the statute would jeopardize, the business as a going concern. So my guess is no, but we'll see what the guidance from the Department of Labor looks like when that comes out.
Right. There's also another theme about the 2/3 payment, the 2/3 pay when we're taking care of either under paid sick leave or FMLA, taking care of, under the FMLA would be taking care of a family member, it's a son or daughter. Does that apply to your exempt employees? And the answer is yes. The regular rate calculation is a little more complicated sometimes for an exempt employee, but there is a way to do that. So yes, it would apply to exempts. The statute does not, exempts, so to speak, from its coverage. But right. I saw a number of questions about that.
Yeah. One really good.
There was a question. Oh, go ahead, Bill.
Go ahead. I was going to say one really good question I saw that I think is going to come up a lot is this leave considered to be intermittent leave, continuous leave, or both? Again, that's not answered by the text of the legislation. So the issue is if you have an employee who says, well, my kid's home from school and maybe I can telework, for certain hours of the day, but not for other periods of time. So I want to use half a day of this new paid leave. Can I do that? The statute doesn't answer that question, and hopefully the Department of Labor will shed additional light on that. I think, absent some further guidance from the Department of Labor, the answer may well be yes, because you can certainly use FMLA leave intermittently in most cases. But we just don't know the answer to that right now. Tracey, I don't know if you had any other thoughts on that.
Yeah, in fact, Bill and I talked about this before the call, that you might have a circumstance, especially in the paid sick leave part of the statute, where let's say you have a family member who's been self-quarantining for a period of time. They've been doing okay at home, and then, they're in day 11 of their 14-day quarantine, and then their health declines, and they do need some care at home. That would be a situation where you could maybe only use, let's say you need to help out for 3 or 5 days. You're only using a portion, and then you may still have some of that sick leave entitlement left in the event, someone in your own household becomes sick, or there's some other reason that you may need to, you're unable to work and you need to be at home. So there could be some interruption in that sick leave, in the use of that sick leave entitlement.
Correct. Just one clarification, circling back to our brief foray into the WARN Acts. Somebody had asked what's the higher precedence of WARN under federal or state. I assume the question is which has a higher threshold. Federal WARN is generally the higher threshold, but I think I do want to point out, because the person who asked this question, I believe, is a public sector person. WARN Act generally only applies to private sector businesses, not to public entities. So just for all you public employers out there, WARN is not necessarily something that you need to worry about.
Right. There is just a question, just to clarify, in terms of eligibility for these two statutes, just to be clear about which is triggered when. The paid sick leave entitlement is 30 days of employment, and they are eligible for it. For the emergency FMLA, it's day one. I'm sorry, you should reverse that. It's day one for sick leave. I'm sorry, day one for sick leave and 30 days for FMLA. For FMLA, that 30-day eligibility is not changing anything about what I would call, regular garden variety FMLA. If they're off for some other FMLA covered reason, baby bonding time, whatever, it is not changing anything with respect to eligibility under the default provisions of the FMLA. This is only for this very specific form of school closure / daycare closure leave.
Right. We had a great question as to whether, again, in the public sector, employees deemed essential like 911 operators, for example, water department employees, sanitation workers, other essential public sector employees would be considered first responders. At least, again, there's no definition of what constitutes a first responder in the statute. So hopefully the U.S. Department of Labor will clarify and will recognize that, beyond, sworn police and fire personnel, EMS personnel, there are categories of public sector workers that are absolutely essential to, the health and well-being of all of our communities. But right now, unfortunately, I don't see that guidance anywhere in the statute. So hopefully it'll come from the Department of Labor. I would encourage, given the tight timeline that the Department of Labor has to issue these regulations, this is not going to be the typical notice and comment regulation process. These will be issued on an emergency basis. But to the extent that you do represent public sector entities, continue to talk to your representatives in the federal government and express these concerns to make sure that they're being heard and hopefully can be addressed either through regulations or follow-on legislation if that needs to happen.
Okay, well, here's a good question about if a full-time employee is given the opportunity to work remotely but does not, what happens? I think a couple things can happen. If I'm able to work remotely and I'm refusing to work remotely, I'm not eligible for either of these leaves potentially. If I'm unable to work, if I offer the opportunity to work remotely and I refuse it because I'm too sick, or because, to Bill's point earlier, he gave the example of taking care of small children due to a school closure, that those small children require constant attention, and I'm telling you I can't work remotely because my kids will burn the house down. Then I think they're turning down the remote work would be justified, and they can invoke either paid sick leave or the extended FMLA in that circumstance. So I think you have to know more about why are they refusing the remote work.
I think that's right. Another great question in the higher ed context, would student hourly workers be eligible for the emergency sick leave pay or potentially emergency FMLA leave? We don't know the answer to that question right now. I think it comes down to would the FMLA or Fair Labor Standards Act otherwise consider those students to be employees. If they're regarded as employees under the FLSA for minimum wage and overtime purposes and not considered, primarily in their student capacity like some sorts of student workers are, my guess is that those student workers would be eligible for leave under these provisions. But, again, it's not something that's directly addressed in the legislation.
Here's a question about, do you expect that employers this is something that has driven all of us crazy at Franczek for the past week or so. Do you expect that employers with more than 500 employees will follow the requirements for those with less than 500? I think that was Congress's understanding, is that those policies were already in place with larger employers. In fact, it was either the New York Times or the Wall Street Journal did an article on this and said that 89% of large employers have some form of paid sick leave. Unfortunately, their leave entitlements do not approximate what is granted by this legislation. I think they discovered that the average was 8 paid days. So it certainly does not go as far as what this this new legislation is doing and imposing on, potentially significantly smaller employers. So we really don't have an explanation for that other than, there's this belief by Congress that, the big mega employers already had this covered, but I don't think that that's universally the case.
All right. And with that, we are at the end of our time for this webinar. There are a ton of questions that I know we did not have a chance to answer in the course of our conversation today. So again, as I said at the outset of the webinar, we will do our best to try to address at least the common themes that we're seeing in these questions as we continue to communicate with all of our clients. If you're not on our mailing list, you can access all of our alerts through our website at franczek.com. Please, again, feel free to reach out to me or Tracey or any of our colleagues at Franczek if you do have questions about specific circumstances as you and your organizations work to comply with these new laws and deal with this ongoing COVID-19 crisis. With that, thank you all so much for attending, and everyone have a great afternoon and stay safe.